Good afternoon, sir.
Nice to see all of you.
I'm going to enable my video.
Well, we can't see you, Mr. Fatobu, so we can't say the same.
I got it.
Oh, is that Mr. Okunu? Mr. Okunu, we can't see you, sir, so I can't say nice to see you. So nice to hear you, sir.
Yeah, we are looking for trouble.
No, it's not trouble. I'm just being specific.
Okay.
Shubu Allah Abraham. Hi, how are you? Thank you for joining us.
Okay.
Tolani, thank you for joining us.
Okay. Abby, I'm about to start. Yeah.
Thank you for having me.
Okay. Good morning, good afternoon, good evening to everyone of Moria watching us. You're welcome to another interesting session of the hot seat. And today we have the learned soak on the hot seat today, Seni Adio, SAN. Thank you so much, sir, for taking time out to be with us. I'm looking forward to this session. I can promise you that, sir.
Thank you. Thank you for having me.
Yes,
like I said, you've been so kind. So I'm looking forward to it.
Thank you so much. Abby, could you do us the honors of reading out the learned soak sample file?
Sure. Good afternoon, learned soak.
Thank you.
Good afternoon.
Thank you for joining us today. So, hello everyone. Thank you for joining us. Good afternoon, good morning, good afternoon, and good evening. Today we have with us Seni Adio, SAN. He's a senior advocate of Nigeria and managing partner of Copley Partners, Lagos. He is the past chairman of the Nigerian Bar Association section on business law and a member of the National Executive Committee of the Nigerian Bar Association. He's also a founding member of the National Assembly Business Environment Roundtable, a think tank comprising of the leadership of the National Assembly, Nigerian Economic Summit Group, NBA, SBL, and Enable to a DFID UK advisory and consulting program established to enhance the ease of doing business in Nigeria. Mr. Adio has over 3 decades of experience as a legal practitioner, including international and domestic. Notably, before returning to Nigeria, he practiced in the law firm of Mintz Levin in Boston, Massachusetts, where he achieved the remarkable feat of becoming a partner in the firm. While there, he represented multinational conglomerates and private companies on various matters, including complex commercial litigation, arbitration, mediation, fiduciary law, and corporate governance, tax abatement, public procurement, and infrastructure development. He also participated in legislative and regulatory matters before the United States Congress, and in particular, tort reform and insurance. Mr. Adio is active in civic societies, has served as a trustee on boards of various not-for-profit organizations. He has also served on the boards of business organizations and currently is a director in the Udua Investment Company Limited, where he chairs the Governance and Nominations Committee. He is a proud alumnus of the veritable Igube College, Yaba, Lagos, and a recipient of the ICOBA Merit Award. He obtained his Bachelor's of Law with honors from the University of Buckingham and Master's in Taxation from Boston University School of Law. He enjoys running and completed 2 Boston marathons. So today we're going to have a packed day. Glad to have you here, Leonard Silk.
Thank you for having me.
Fola, over to you.
Yeah, thank you so much, Leonard Silk. Okay, for the benefit of those joining us for the first time today, today is not a training session. What we try to do is to connect with anybody we have on the hot seat to know the essence of why they do what they do, especially in the business and practice of dispute resolution. So today we have the learned soak on the hot seat. And like I always say, the journey is as important as the destination. So you can't have the learned soak on the hot seat and start asking basic questions. So I'm going to hit the ground running and starting off with this. Learned soak, have you always wanted to be a lawyer?
I think so. I guess partly because, I have a fairly a long lineage of lawyers in my family. So, for example, both my parents, when the legal profession, they're of blessed memory now. So, so my mom was a former High Court judge of Ogun State, the Ogun State High Court. She passed quite early. Otherwise, I think the sky would have been the beginning for her, but she was in court too when she passed. But my dad became chief judge of my state, Oyo State. And my uncle, my dad's older brother, was a justice of the Supreme Court. So yes, I had an affinity towards the law from a very early age. And besides, I was never good in numbers. So sciences were not my forte. So I thought I was interested anyway, but also a safe bet in terms of a career. Yeah.
Okay. Yeah, thank you so much. Now, if we look at your legal pedigree and your early years in practice as a lawyer, and we now fast forward to the legal profession right now, what happened, Lenesok? I think that word is loaded. What happened? Where did we get it from?
Yes, you are starting very early to put me in very tight corners.
Yes.
I have a sort of a perspective that is perhaps different from many who have been at the bar as long as I have, not by design. And the reason being that, right after I qualified, after youth corps, I traveled supposedly for a year to do a master's degree in the States, and a year became almost 16 years. I was in Boston. So for many years, I was practicing in the US. So a lot of the good old days, so to speak, I did witness some in practice, not for long. I witnessed a lot through my parents and my uncle. But then I came back in 2004, back into the country, and got back into practice, I think a couple of years after that. So, but I know what you mean by that. There's still a lot of outstanding practitioners out there who conduct themselves with the utmost decorum, are very adept at what they do. They have the gravitas, they are very compelling in courts, and they conduct themselves with utmost integrity, which I'm sure is part of what you're alluding to. But it's also true that a lot of things have changed. There are a lot of lawyers who are very casual in how they practice. There are a lot of lawyers who don't take very seriously the responsibility to keep client matters confidential. There are a lot of lawyers who are very sloppy, both in their work and in their appearance. And the list goes on, but I don't think all is lost yet. And there are a lot of people who are out there still very vigilant and who are looking to mentor and correct those lawyers who perhaps are not conducting themselves the way they ought to. So that would be my response in a nutshell.
Okay, thank you so much, Lenesok. And we're going to look at the challenges surrounding litigation from two perspectives. First, from that of the lawyers. And there seems to be this, now for every young lawyer called to the bar that I have this conversation with, asking them whether they want to come into litigation, it's always a big no. They don't see, in their words, they don't see the benefit of them coming into litigation, because they believe, apart from being poorly paid, quote and unquote, they have this feeling that, look, matters go on for years without end and all of that. I would like to hear what your thoughts on that are from that perspective, and then from the perspective of the end users, who sometimes we call them clients and all of that. They are also, some of them are not beginning to, they're not really seeing the benefits of litigation as more as such. They believe cases are in court for years without end, among so many other things I think we are both familiar with. So can we first look at the challenges from that end, from both angles, before we take it to the next level?
Okay, well, let me start with, you had said that a lot of young lawyers aren't interested or tend not to be interested in litigation these days, which you're absolutely right about that. In fact, I know some young I would say graduates. They've read law. Some have refused to go to law school because after reading law decided, they don't want to practice anyway. So why bother going to law school? And even I've had to mentor some of them and convince them that, look, even if you don't end up quote unquote practicing, you only become a lawyer by getting admitted to the bar. And moving beyond that into, young lawyers not wanting to get into litigation or dispute resolution. I tell people, maybe I have a bias towards dispute resolution, that, I think invariably, even if you go into commercial work, whether into M&A or taxation or intellectual property or what have you, I think that there's some skill sets that you acquire as a trial lawyer. With all due respect to other, legal practitioners in other spheres, but, in terms of, being very quick on your feet, in terms of being able to understand more than the nuances, but certainly the nuances in documents, for example, because as a dispute resolution practitioner, you get to court, you were not there when the documents were prepared, there's a dispute, and when you read the documents, sometimes, you're thinking, how did the client sign this kind of an agreement, for example? And I think that if a lawyer had been in this resolution, perhaps in litigation for a number of years before veering into commercial work, a lot of things, I think you'll have a better perspective as to how to avoid certain situations, and also maybe even how to be mischievous when you want to create ambiguities knowingly, not inadvertently. So sometimes it may be to your best or client's interest for there to be gray areas, but you've done that on purpose. So that'll be my part of my sort of advocacy in terms of people trying to litigation for at least 3 years perhaps before you go into other areas. And I recall that, for example, when I started practice in Boston, the firm that I was with would allow lawyers to rotate into 3 different departments, into your 3rd year, and then you choose one. The idea was to expose you to different areas, and then you go into one. And so for me, I thought I was going to be a tax lawyer or a commercial lawyer. And so I went into litigation first, although I think psychologically, I also was perhaps running away from what my dad in particular did. He was a trial lawyer all his life before he went on the bench. So I think I was also trying to perhaps to get away from that. But then I found that I loved litigation. So I did do some commercial work for a while, that I stayed in litigation, and I have no regrets about it. It's also true that in this environment, not everywhere, that for the most part, the firms that are just strictly engaged in this resolution perhaps are not, the high profile, they're not as successful, they're not the quote unquote, perhaps blue chip firms, but there are also some firms that are boutique firms in this environment that are doing very well, handling very sophisticated matters, so I think it's what you make it really, and there's some lawyers too who have been very successful in almost straddling being fairly commercial and also being excellent advocates, so and then again, sometimes what happens is that even the commercial firms sometimes will get the firms that are more dispute resolution focused to handle or lead them in very complicated commercial cases. So again, I think there's always room. I mean, for example, we recently we got approached by a firm that's a boutique commercial firm that, look, why don't we have some kind of an understanding that when they have clients that have dispute resolution issues, they'll refer them to us. And of course, we're not going to poach their client. We'll just do the work, and then, and that's the end of that. So I think there's a lot that can be done in terms of this resolution in this environment that is not being done, because even in that space, you can specialize. So you can be a litigator that your specialty is in intellectual property. You can be a litigator that your specialty is in antitrust, or white collar crime. And abroad in the States where I practice, for example, some of the the highest fee earners are dispute resolution practitioners, based on contingent fee cases that they take. So I think there's a lot we can still do in this environment that we're not doing yet, but I'm sure we'll get there.
Okay, great. Thank you so much. You mentioned you have a bias for ADR. So I'd like to ask you, what are the challenges of litigating, business disputes? And how do you see mediation being used, or ADR, actually mediation, being used as a remedy?
Well, the challenges in this environment, and we all know what they are, expensive, delay. Also, when you go into litigation, invariably relationships are damaged, invariably beyond repair. And so on and so forth. There's also the issue of, even though as lawyers, we all are familiar with the, legal maxim of stare decisis, but oftentimes, you go in, it's almost as though you're going in blind, which is very disturbing, because as lawyers, especially senior lawyers, should be able to predict within certain parameters the outcome of, or the likely outcome of a particular situation, But in this environment, oftentimes, you can't, So what mediation does is that we can try and resolve your matter confidentially, hopefully amicably. The relationship can still be salvaged. It's confidential. Invariably, it's less expensive. But I think that a lot of lawyers resist mediation, either consciously or unconsciously, some because they think it might affect their fees, and some also don't even consider it because they think that it sends a signal of weakness. So even, for example, when I first came back, if I have a matter, it wasn't uncommon for me to pick up the phone and call opposing counsel, or maybe write a letter or send an email. But I found that, it's changing somewhat now, but I found that invariably people will take that as though you're not confident about the strength of your case, which is most unfortunate, And so that's one challenge in terms of attitudinal challenge, disposition that we have to change. That, look, lawyers should not feel when you try to be collaborative or conciliatory is a sign of weakness, And one of the things that we could even do, for example, in the US where I practice, Massachusetts, to give an example, there's some statutes. I can't believe I still remember some of them. It's been a long time, but there's a statute called the Massachusetts General Laws, Chapter 93A. It's like a consumer protection statute, and there's another one, 176D, which deals with insurance. And in Massachusetts, once a potential claimant writes a demand letter, to you, a potential defendant, making a demand. One, the law requires you to respond in writing. The law requires you to make an offer in writing. The law expects that the offer that you would make would be a reasonable one. Now, if you don't respond at all, and that person is forced to sue, and that person wins, it is automatic. It's not discretionary. It is automatic that the judge is going to award treble damages, attorney's fees, and costs against you. So you can imagine if the claim is like, for example, $1 million, and you lose because you didn't respond, that claim now becomes $3 million. If that claimant had hired, a lawyer in a big firm that's charging $1,000 an hour, and it took perhaps 2 years for the case to be concluded, it's possible that the fees from that case could be $1 million, and so on and so forth. So all of a sudden, a $1 million claim can become almost $5 million by the time you have to pay. So the law encourages parties to not necessarily mediate, but at least be conciliatory and make an attempt to settle the matter. Now, if you respond in writing and you make an offer and it's refused, even if the person wins, so long as the offer that you made was in the circumstances reasonable, the person only gets what that person is entitled to in terms of whatever damages the person proved, right? So again, in that environment, the jurisprudence sort of encourages parties to try and resolve disputes amicably. And if you can't, but you've tried, then you're not in peril. But if you don't, you could be in serious peril. Now, in this environment, like I said, a lot of people there's also a misconception, yes, in this environment that mediation is not binding. Yes, a lot of people think that mediation is not binding.
Leonard Silk, you're answering all my questions now. I actually
sorry.
One question. I'm just checking my list now. You answered like 3 already.
All right, I'll stop there.
I think going forward, we should be laying some ground rules. When they answer the question, they should pause.
My senior is smiling. Mr. Okuno is smiling. That okay, Mr. You're just running with it. Okay, it's all right. I'll try and.
Thank you. I was just joking. That was just an aside.
No problem.
I was just joking. Yes. So from everything you've said, how is it possible for us as legal practitioners to plug into is it possible for us to plug into collaborative reconciliatory law? Because I ask this because there's a mindset, apart from the fact that there's a misconception that mediation isn't binding, there's a mindset that mediation is the poorer cousin, or mediation is a process that shows you are coming in from a weak point and you don't have a good case. How do we plug in, or how do we imbibe? In view of the fact that you have been chairman of MBA, I didn't want to go back. I mean, as I was reading it, I was looking for water.
So
how do we?
Sorry, Abby, I don't know what I had a question like that. So can I just flesh in your question so that the learner can just take everything in block?
Sure, go ahead.
Yeah, it's still within the same line of questioning. And learner, I think I'm just going to just hit the nail on the head by mentioning the issues lawyers have against mediation. 3. 1, the issue of the fees. Then that misconceived notion that the case is about them and not the clients. Then I think that I don't want to say that some lawyers have actually forgotten the essence of why they do dispute resolution. So my question along that line is this: look, why can't they see mediation as a collaborative means of dispute resolution than see it as than them having this rival attitude towards mediation? I just don't understand, because it's reoccurring. It always comes up at every session where you see lawyers just become so antagonistic of mediation. And of course, we know what the bottom line is. So do you think it's a mindset thing, or is it a selfish thing? And this is just picking on the side of the lawyers. I'd like to hear your thoughts on this, sir.
Yes, I think it's a combination of everything you've said. And I think it's also a combination of, with all due respect, there's no other way to describe it but ignorance, you know. And some of it also lies, the responsibility lies with a lot of us practitioners. And I think what this is about, this platform, for example, is a very good one to sort of continue to get the message out and what have you. But the thing is, you know, there are a lot of opportunities and mechanisms to go into mediation, to have dispute resolved through mediation, that most lawyers, I won't even say many, most lawyers don't explore. I would even say maybe most lawyers don't even know about, you know. So for example, I'll raise my hand, right? So for example, I haven't had to check the Supreme Court rules, but I'm aware that whether it's through practice direction or some mechanism, there's a mechanism for, even at the Supreme Court level, to mediate disputes. Certainly at the Court of Appeal level, I know there's, I think it's Order 16 of the Court of Appeal rules provide a mechanism, even at the Court of Appeal, for parties to go and mediate. I've never used it. I don't know anyone that has ever used it. So we have some of this mechanism and they're not being used. There are all kinds of reasons for that. Again, people don't know they're there. People are not interested, perhaps. People are also concerned about it affecting their fees. Then you have people who want judgment based on an adversarial setting because of all kinds of reasons, including those who are chasing silk, because you need a judgment. You know, you need a judgment in order to be able to use that for part of the application. So that may be a disincentive that some people are just not going to go the mediation route because they need actual judgments for them to be eligible to apply for the rank of senior advocate. So you have that issue. And then, yes, and then you have, so even let me give an example. The only time since I qualified that I worked outside a law firm environment, was when I first came back. I worked in-house kind of for like a couple of years with a gaming company. And as the chief corporate services, legal was, under my jurisdiction, and I remember we had an issue, and we gave the brief to Professor Bolahon Elias, who we have a bit in common, including he's also an alumnus of Bobby College. Anyway, we gave him the brief, and he gave us an opinion. The opinion was a paragraph, right? It was just a paragraph. And even I thought, wow, you were going to pay XYZ for this? But the answer was right there in that one paragraph. But my mindset was, I don't know if Chief, my chairman there was Chukola, I see that, I don't know if he's going to be enamored about paying X amount for something like this. But so you can imagine, with all the supposed exposure and sophistication and whatever, that was the knee-jerk reaction that I had. So if you mediate and you solve the client's problem very, very quickly without a lot of acrimony, some clients too will just think, well, Mr. Adio, it didn't take long now. What did you do now? That don't you think, ahead then? So as opposed to you solve the problem quickly, it was painless, the relationship with the other side has not been destroyed, and all the other benefits, they don't see that. So I think even the business community too, needs to also maybe further embrace mediation and other, processes in terms of ADR, and then in-house counsel too, because if it's a company you're representing, they too should appreciate that, is the experience that you've developed over 10 years, 20 years, 30 years, whatever it is that you brought to bear to get there, what appeared to be very knotty issue resolved perhaps fairly quickly, and still appreciate and pay, good value for that kind of a prompt resolution. But it's not something that is happening at the moment, so we all have to continue working on that. Regarding the issue about lawyers think it's about them and not the clients, I always tell, the way I was trained, right, is that, at the end of the day, particularly when you're handling maybe bet the company cases, no client is interested in whether you can write the best brief, or you have juniors that can do the best research. They've come to you because they know you're a good lawyer, you're a good firm, you'll do excellent work. They already know that, or they expect that anyway. What they want is to have their problem resolved, and resolved as quickly as possible, and get them the best outcome we possibly can. That's what they want. So a lot of lawyers, sometimes they get a matter and they want to show off their skills, their knowledge. They want to drag the case for a bit, again, maybe being motivated through pecuniary reasons. But sometimes they just want to show off. They want to, I tell people that when you get to court, those of us who are litigators, we know this, right? Which is that, you get to court, you see someone and you say, this guy is outstanding. He's marshaled all the facts, he knows the law. Those of us who do the work, we know what kind of industry must have gone in for that person to be able to come and do what they've done. Because when you get into court, as I say, it's showtime. You can't get to court and the judge knows the facts of your case more than you do, or somebody else, So again, some lawyers feel the need to come, let their client be there and see all this drama before they start thinking about the resolution. So you're right. Not all lawyers are like that, but I guess many more lawyers need not to be like that. But I think the business community also needs to appreciate lawyers that are able to resolve their matters very, very quickly, as they are appreciated in other climes. So for example, let's give an example. In other climes, for example, which doesn't, say for example, you are a CEO on Wall Street, and you or your company is being investigated for potential violation of some, law, maybe securities law or something, and those are potentially criminal, right? So unlike here, there, SEC or the U.S. Attorney's Office, they don't go to press to disclose anything that are being investigated. Everything is done. The only time people know that there's a problem is when you're charged to court or a grand jury is convened. But even what's happening in grand jury, they don't know. They just know that you've gone to court, the grand jury has been convened. They don't know what the case is about. What I'm trying to make is, in those kind of situations, those companies, for their CEOs or for themselves, they will look for the best minds they can get. They will pay whatever it takes to get that lawyer to try their damn hardest to try and get the matter resolved as quickly as possible with the regulator, so it doesn't get into the public domain. And they'll pay a premium for that. So,
great. Leonard Silk.
Yes, ma'am.
This is your second morning. When
Okay,
we ask you questions, just I understand.
3 strikes and I'm out. Okay.
Yes, Leonard Silk. And I'm the one who's going to put you out. So I've said it there and I put it there. So please,
Right.
and you're making people like me feel. I have like 7 questions. You've answered I've not even asked you. I've answered 5 questions.
Okay.
So you remember that little child that said you need to be calming down. Leonard Silk, please, let's be calming down. Okay. Thank you. Thank you so much. So there's a question from Mrs. Colade. Yes. So it says, if lawyers deliberately go to court because they're counting cases towards stock rather than deploying the best dispute mechanism for the cases, is this then not about the lawyer rather than the client? Can this be said to be good representation?
Well, the way she has put it, assuming that is happening, then yes.
Leonard Silk is happening.
No, wait,
we all
let me
know it's
finish.
happening. Why are you saying
have-
assuming? Okay, so assuming without conceding.
Conceding. I like that. You took those words. Assuming without conceding, let us say.
So please, let's answer question, Leonard Silk. And this is something you know about. You had touched on it earlier.
Assuming without conceding, that would be
Yes.
the case. That maybe you're putting your, own personal circumstance above, the clients in terms of, pushing it. Now, and that's not proper, right? But I think invariably.
Sorry, I didn't hear that.
I said that's not proper.
Thank you.
But invariably, I think what happens more often, it's not the lawyer putting himself or herself at the fore instead of the client's interest. I think what it is that I think is that even when the client may be getting weary, right, or may be running low on their willingness to continue to fund the matter. I know that they're not going to fund it, but they're just getting weary. Sometimes, a counsel may, and there's nothing wrong with that, may decide that, look, okay, either you want to do it pro bono or you want to do it for a discounted rate, so that it becomes a win-win. If we prevail on the merits at the appellate level, the client obviously will be elated, and also we have gotten that victory at a discount. So I think that happens more often than just wanting to pursue a case that lacks merit just because you want a judgment. I think what happens more is just willing to be flexible. The lawyer willing to be flexible in order to help the client get a result, but at the same time, obviously, the appellate judgment would also be beneficial for the counsel.
Thank you so much. Lanre, can you please unmute yourself?
Mr. Adisa had his cheek in his palm, and I'm not sure he was convinced by that explanation, but that's my response, and I'm sticking to it.
Well, he's just shrugged like, okay. So Larry, please, can you be succinct about your question? Thank you.
Sorry, before Larry takes his question, Mrs. Colade asked a question which is almost along the same trajectory. So I don't know whether the Leonard Silk can just quickly take that question, and it goes thus. She says that
oh, my apologies, ma.
Yeah, she says that. I like this question. Why do SCNs resist Why do SCNs resist mediation, and what can be done about this? Is it because their title depicts them as advocates?
I don't. Mr. Kolade is a very, 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 very senior lawyer, so I'm sure she's speaking from experience. I think that, again, I think some SCNs perhaps resist mediation or are not enthused, should I say, because maybe their experience in the past have been that issues were not resolved, number one. The experience also may have been that the mediator, again, with all due respect, was not, and that's the thing. Okay, that's the thing, that mediation, right? So the mediator is there to mediate. It's not there to, cajole, or maybe not cajole is the word, but it's not there to coerce the parties or a party into a position or make recommendations or what have you. You're just facilitating, and the parties are talking, and you're relaying information back and forth, and you're trying to bring them together and let it be their decision, right? Now, it's possible that some SCN may feel, why do we need someone in the middle to just be there for us to be talking and hoping that we'll come to a landing? If that person not going to, sort of kick someone from the behind or one side or the other, so maybe conciliation is what that person may think that will be more useful for them in the circumstances. But I think part of it is that a lot of people also don't understand going into mediation that the mediator is not meant to give suggestions or advice, and it's also possible that maybe some circumstances, again, with all due respect, maybe, if it's, and I think most people, when it comes to mediation, the ones that they end up having been experienced or encountered maybe has to do with the court-ordered mediation. And in those circumstances, the people conducting those mediations, not all the time, but I've been to some, sometimes are not necessarily the most adept and, knowledgeable, I'm sorry, and so on and so forth, that maybe some SCNs feel, it's not worth their time or their client's time for that matter. So it could be that. So, but maybe what they should be thinking about is, there are a lot of excellent mediators or ADR practitioners out there. Mrs. Kolade is certainly one of them. So what the party can do is agree that, okay, well, let us decide who we're going to choose and have somebody that has the gravitas, the knowledge, the experience that, can help us arrive at a landing, hopefully. I think it's a combination of those kinds of issues.
Okay, thank you so much. Larry, your hand was up. I don't know whether you still want to ask a question. But sir, before I can't find Larry here. But what are your thoughts really on mediation? That is subjective answer, Lenny. So, what are your thoughts on mediation? And on the flip side, what are the challenges? What are the things? I don't want to use the word things you have against mediation, but what are the challenges you see that go against mediation? It's a subjective answer, Lenny. So, I would like to hear your thoughts on this.
Okay, for me, there's some challenges, yes, but a lot of the world I would have considered from a subjective perspective, issues that I could have had or perhaps may have had, maybe consciously or subconsciously regarding mediation, I now know better. So let me raise my hand up. I also was one of those people that thought mediation is not binding. Yeah.
Mm-hmm.
Yes. So, but my thinking is that, well, I can come to mediation, and we mediate and we mediate and we mediate, and if I don't agree, nothing happens, or my client doesn't agree, nothing happens, right? Whereas, at the extreme end of ADR, you have arbitration, and once you submit, if you don't show up or you don't participate the way you ought to, and now what is going to be made, and it's going to be binding on your client, right? Whereas in mediation, unless we put pen to paper and we sign, there's something that's going to come out of it, essentially. And really, really, you also cannot go and to use our parlance here, so we are going to go and report me to somebody that we did not do this or did not do that. So, so that was one hang up, if you will, that I had about mediation. But I have since come to realize that, again, as lawyers anyway, you're supposed to come into a situation acting in good faith, and so on and so forth. And if you're acting in good faith, and the other side is acting in good faith, then at a minimum, even if you don't resolve the matter, you would have had some reality checks. You would have, that process would have served like a way of evaluating your case.
Okay, providing clarity.
Clarity, yes. Maybe even give your client a chance to know how strong or weak their case is. So maybe even it strengthens your hand when you need to tell your client that our case is not very strong. When that client would have heard from a third party that, look, these are the issues that I see about this case. Or maybe from the body language of things that the media would have been saying that, look, maybe we really need to, moderate or manage our expectations and try and resolve. So from my perspective, I've been a convert for a long time. So subjectively, I don't have any issues whatsoever about mediation. In fact, one of the things that I observed is that, the Lagos, the Lagos State Civil Procedure, High Court of Lagos State Civil Procedure rules and the pre-action protocols there, the language, the wording of the pre-action protocol is not strong enough in terms of mandating mediation. It requires you to demonstrate that you have considered a form of ADR. You have considered. What does that mean?
Yeah, I'm sorry if I may interject at this point. Another subjective question. In your opinion, do you think mediation should be made compulsory? That question just came to mind from what you just said. Do you think it should be made compulsory?
So, no. Let me just first answer the question. And I think maybe that answers the issue that I posed. I don't think it will no longer be, I don't know whether, I was going to say it will no longer be mediation if it's, in the way that we know it, if it's made compulsory. It should be voluntary, it should be voluntary. But I think what should happen is that, if you go to mediation, let it be that, all of us have, exhibit a certain level of fidelity to our profession, to the process. And if you do, again, a lot of matters to get resolved. Those that don't get resolved, at least you get a good sense of how strong your case is. But I don't think it should be made mandatory. And that's perhaps the reason why in the pre-action protocols, it doesn't say you must have gone to mediation. It just says that you must demonstrate that you've considered one of the ADR mechanisms. That's what it says. So the short answer is that I don't think it should be mandatory. No.
Yeah, maybe I didn't give a bit of context to the
question. Sorry, let me interject. Fola, let me interject. Okay. Fola, my name is Larry Olayinka. Just to what you said and my response, the Constitution gives you access to court. That is your constitutional right. And like the learned Silk said, mediation is, you have to consent to whatever is going on, vis-a-vis arbitration, where if you don't turn up and arbitral proceedings are concluded, there'll be an award. So from a legal standpoint, if you say mediation has to be compulsory, then I'll challenge it on my constitutional right. It's as simple as that. So I think it's best to leave it to parties to decide whether to go for mediation or stick to their guns and go to court. Like Leonard Silk said, if we don't resolve at mediation, a report is written and we go back to court to resolve it. But from my little experience, I found out that during mediation, many issues are resolved. Many issues are resolved, where both parties have had trends or Israels. That is, everybody's sticking to their guns. you find out that if we discuss issues and we talk, we can easily resolve issues. For example, there's a mediation I'm doing presently. I mean, the hatred amongst the parties is not only theatrical, it's dramatic as well. But we made mediation. The first day, we all laughed and we moved on. And of course, if mediation is concluded and parties agree and we all sign, you get your fees and you throw away the file.
I'm sorry, Mr. Larry, can I just interject? Because maybe if I give a bit of more context to my question, you understand where I'm coming from, and the learners so can basically look at it. Now, if we look at court-preferred mediation is mandatory mediation, where the court so moto looks at the case and decides on its own that this case is a case that should be referred to mediation.
I still have to consent to ask parties whether they think. Mediation.
Yes.
I still have to consent.
No. That's where I'm going to, sir. No. That is where I'm going to. Now, the issue of mediation being mandatory, for me, in my own opinion, is a scenario where parties are first of all mandated to go to mediation. Then the issue of voluntariness, as far as whether that case should be mediated or not, should be at that point. Now, so there are two different cases entirely, because now I say this because I'm trying to infuse culture into mediation now, because you see, the problem we have right now is that barrier of the lawyers, and because mediation essentially is party driven, the lawyers are always the first port of call for parties and clients. Now, unlike litigation, so you see, it's a function of, okay, fine, how do we get the parties above, how do we break that barrier and make the mediator and make the parties see the essence of resolving disputes on their own? So what I'm trying to look at, or the point I was trying to bring up to the learner circle is that mandatory mediation at the point of, yes, let mediation first of all be the port of call. More like you dragging a horse to the river, and the choice of whether the horse will drink water from the river should entirely be left to the horse. That's the angle I'm looking at it from. So I don't know whether, in view of what I just explained, yes, sir, in view of what I just explained, yes, I don't know whether your response will still be the same.
No, I'll let you.
Let me hear you, sir.
I'm sure Leonard could agree that at times the attitude of lawyers is what prolongs litigation. Some lawyers don't advise their clients honestly. They don't. They'd rather, let's do this case for 20 years. I'm not into that school of thought. As a lawyer, you also have to think like a businessman. I'm not saying you compromise, but you see what is best for your clients. I'm sure lawyers on this platform from experience would have gone through a situation where the issues are very clear. Let me give you an example. The mediation I'm doing presently is a very clear issue. The other party says the man died, is from the East, he died. And they said, oh, because my client does not have or never had a male child, they would take first. It's called the Idiopa by the Igbo tradition. And I told them, go and read Ukeje versus Ukeje. It's quite clear. It's very, very clear what Rosevival said. You cannot disenfranchise me because I'm a girl. The lawyer wrote back to me and said it wasn't applicable. Common sense approach. The law is there. He told me it wasn't. Now we're at mediation. Now they agree it's applicable. We must take first. No. You see, so at times it's the attitude of lawyers. Attitude of lawyers. If we look at facts as easily as we should, using our legal experience, litigation shouldn't take years. In fact, we'll be the ones mediating between the parties and not even waiting for the court to tell us to go to mediation. So you see, that's another perspective to the issues. If you disagree, fine. If you agree, it's okay. But I'm telling you from my relatively small experience as to what we do, lawyers. You know, there are some lawyers that they are dependent on pay me per appearance. We don't do that. It's total waste of time. I charge you fees, you pay me. I look at it. I advise you, and I move on.
Okay, yeah, thank you so much.
I don't want a table. I don't want a file on my table for 10 years. Doing what?
Yeah.
That is over trading.
Yeah, thank you so much. Leonard,
you're laughing. Is the truth?
No, I agree with you. Yeah.
Can we hear your thoughts on this discourse?
No, I agree with Mr. Alaika. I agree with him. By the way, Mr. Alaika is a good friend of mine, and my classmates, go back a long way. We even served, we did youth court together in Jos, so he's a good friend. I agree with him totally, and I think that's one of the benefits of mediation that, and the lawyers should also see about mediation, for example, that, if you can resolve 10 cases in, a relatively short period of time, as opposed to, one case that's going to last over and over again and for many, many years. By the time you're in your 6th or 7th year, even the fees that you got, those fees have gone. You're now trying to be creative or resourceful of how you're going to now build the client for something, for additional fees. And oftentimes
that could amount to stealing.
Exactly. And oftentimes that's always a tough conversation, because the client feels, we agree this amount, and I'm going to half at the beginning and half at the end, or half at the beginning, another quarter in the middle, and the balance is at the end. I'm not paying anything beyond that. But you are thinking, this case has taken 5 years. I need to get, I've been sending people to court. We're getting CTC of this. We're serving, we're filing. You're paying a penalty, which is now, I think, 1,000 naira per day if you don't file your processes in time at the Federal High Court, and I think from Lagos High Court. It's costing a lot of money, and you're regretting the fees that you charged 5 years ago. So, but going back to the issue really of court-ordered mediation, I think you're right in the sense that the way it tends to evolve invariably appears to be mandatory. But unless one goes to look at that process, I'm not sure that what the court does is to say you absolutely have no choice, you have to go. I think if the part, and of course, no lawyer or no party will say to the court, I'm not doing, because you think it might affect your case. What you will do invariably is go, God forbid, but you will be recalcitrant, and then you resolve, and then you come back. And we hope that maybe the person that conducted did not write anything, about your dilatory tactics in the report, But I haven't seen counsel or a party saying when the court is hinting or even directing to go to court-ordered mediation to say we're not going to do it. But having said that, I also have not seen or read anywhere where a party or counsel has challenged the court's ability to compel them to go. So I think the jury is still out on that, whether you can compel. But I've seen, and I think a lot of the agreements that Lagos State agencies and maybe Lagos State government, a lot of the agreements they're entering into now have mediation in them, and of course, invariably court-ordered mediation, LMDC. So we have, I think, a few matters now that is the case. It's in the agreement, and we're in court, and the other side has raised an objection that we ought to go to mediation, and we had no objection or issue with that. So we're going to go to court order. It's not even court order. We're going to go to LMDC because it was in the agreement that our client and the government agency signed. So that may be another way that the state, for example, is encouraging disputes to be resolved amicably through that process. But again, like I said, to wrap up, I just haven't found anyone saying, look, you can't force me to mediation. I think very few people go, and what they do, there's a different thing entirely, whether there's any fidelity to the process or not.
Yeah.
Okay, great. Thank you so much, Leonard Silk. There's a question here from, actually, there are a couple of questions. I'm going to start from bottom up. So there's a question from Gbenga Bello. Do you think that there isn't enough utilization of preconditions to approach courts? That's the pre-action protocol. I noticed these days that the demand letter in itself is the pre-action protocol. And once that letter is sent, a case is filed. That, for me, is not an effective utilization of pre-action protocols. Also, I do not think there is an effective utilization of the CMC pre-trial conference. A lot of trials still go on that are purely a judicial waste of time. For some of these cases, you could tell where the case is headed, yet trial proceeds. I also don't think lawyers do not. I also think lawyers do not get sanctioned enough for pushing clear frivolosities. Now, let's say before you answer this question, the litigation mindset. I would like for you to answer this question, putting, into cognizance or taking into cognizance the litigation mindsets.
Okay, so regarding the pre-action protocol, that oftentimes lawyers just do a demand letter and believe that they have satisfied the requirement. Yes, she's right about that. A lot of lawyers do that, but I dare say that they do that at their own peril, because it's not even, you don't even have to be a resourceful opposing counsel. You can raise an objection that they haven't followed the pre-action protocol, and if that is found to be the case, the law of courts will strike out the matter. If you have a basis for just doing a demand letter and then running to court, perhaps that's not the way I should describe it, but assuming you run into court, and maybe because you did that because there's like the exigent circumstances, that you can't tee off the other side, otherwise they'll hide assets or remove assets within jurisdiction. Even the pre-action protocol provides for preemptive actions, and then you can now go back to conclude the entire process as stated in the pre-action protocol practice direction. But it is true that some lawyers just send a demand letter, and then once they get a response that is not, doesn't admit liability or dispute liability, or doesn't say, let's resolve the matter, they just run into court, But because what it requires you is you do the demand letter, there's a response, you're supposed to demonstrate that you guys have considered ADR. And how did you consider ADR? You're supposed to write a memorandum of claim. In that memorandum, you must state the facts about the case, the issues about the case, the relief you are seeking, and so on and so forth. And then depending on the issue, there are some protocols that are subject matter specific. If it's a land matter, if it's a mortgage matter, the different ones with defamation, that you also have to comply with, So, but if you do that, you are doing it at your own peril. So someone like her, if she gets something like that as a defense counsel, she just file an objection and a motion to have the matter struck out. That's what she should do. That should be the consequence.
Okay, great.
On the issue of CMC, before I answer that question, one issue, I was going to say one beef, but that would not be speaking like a lawyer, that I have with some judges is that, our courts, I should say, is that I found that a lot of times, you bring a motion for summary judgment. And, once the other side files a defense and they file a counter affidavit and this and that, they don't want to grant summary judgment. They were just going to conduct CMC and then you go to trial. And it's really, it borders on even injustice, because sometimes those cases are clear, in my mind, fairly clear cut, that summary judgment ought to be given, because somebody can just because I deny and I file a defense, so what? You have to look at what they've said in the defense now, or what they've said in the counter affidavit now, before you just decide that, okay, they filed the defense, so you guys go to trial. No, or at least give me, maybe if my case, maybe part of my case is liquidated, give me partial summary judgment. But a lot of judges don't do that. And it's really, I don't know. So, so I have a matter now that I think we've kind of concluded or about to conclude CMC, I forget now, but we've now discovered, based on certain admissions, well, they didn't think they were admissions, but based on certain representations the other side made, that as far as we are concerned, this case is statute bad, or it ought to be statute bad. So whereas CMC, I think, has just concluded, we intend to bring a motion for that, and hopefully, the court will be saying, well, CMC has concluded, you guys, it's been sent to the admin judge to be reassigned to a trial judge, and therefore, you are going to go to trial. That would not be, I don't know, it would not be fair, in my opinion. Frivolous actions, sanctions, what is frivolous to A may not be frivolous to B, but I hear what you're saying. For the most part, we all know what is frivolous. And yes, if an action is frivolous, there ought to be sanctions. But you also have to remember that sometimes the courts, to be fair to the courts, they have to balance not chilling the public, from being able to come into court to avail their rights, just because you end up being wrong in terms of what you thought your rights were, or even sometimes you lose, not because your rights were not infringed, but you couldn't prove your case, either because you did a poor job, or all kinds of reasons. It doesn't mean that your case was frivolous. But yes, where it's really clear that it's a frivolous action, there ought to be sanctions, and perhaps sanctions of counsel, that it hits the pockets of the lawyer, not the party. So I agree with that 100%, and I think that is beginning to happen now. And the Supreme Court is doing it and has done it against some very, very, very senior lawyers. So it is happening, yeah.
Okay, great. Thank you so much. There's a question here from Eunice. Is there any ongoing discussion or step being taken by the bench and bar towards ensuring that matters settled amicably would count for a lawyer in the application for senior advocate rank?
The short
Can I
answer,
answer? Can I answer? Because I'm directly affected by that. I
Please
don't
go ahead.
agree. I don't agree with the council that it must be litigation. For example, they ask you to provide all CTCs of all your actions. The fact that I'm able to use my legal dexterity to resolve a matter, and that parties settle without going to court, or even if they've gone to court without trial, should count for me. It shows that you are industrious. That is my view. But, the majority speaks. So some of us now we're here. It's okay. We don't have an issue.
Actually, it shouldn't be okay, sir. It shouldn't be okay.
Let me tell you, Mr. Adio, Leonard Silk is my colleague. And I've said to myself, if I'm not made silk, at least I must have enough money. That's the key. So if I'm settling a matter and I'm being well paid, who gives don't let me use the word.
Yes, I mean,
at the end of the day, it's about the money.
It's about the money.
It's about the money. He has addressed the elephant in the room. There's really nothing. It's always about the money. It's always about the money.
Let me give an example. There's a case
if I may, I want to recognize.
No,
I want to recognize my brother and senior Chief Bolaji Henry, senior advocate of
Oh,
Nigeria.
is it? Wow, I didn't know.
Otumba of the source.
Good evening, sir. I didn't know you were around, sir. Thank you so much for tuning in. Wow.
Let me say something. There's a matter we're doing now. Another SCN is involved. We're able to resolve. They paid the defendant paid 200 million. The lender still doesn't care whether we go to trial or not. 20 million is his own, and they said they should pay it into his account. So I would say, no, don't pay the money. Let's go to trial. That will take me 10 years. Forget that. Let's move on. He's probably in India now.
Yeah, please check your DM. I sent you a message.
Who, me?
we need to have you on the hot seat, sir. We know the type of people who want on the hot seat. Please check your DM. Okay, so let's continue, please. Adi, let's check. We have so many questions in the comment section. Let's take as many as we can take. We have
yes. Okay, so we have okay, so I think we've taken that one. Hold on a minute.
Yeah, there's a question by Mrs.
Oshukaye. Yeah, that's the one I'm looking for. If you've gotten there, read it. I can't. I'm looking for it. I'm scrolling.
Maybe you need your glasses.
Yes, I do. Okay, I found it. I actually do. Thank you.
Okay.
I don't know who that was, but thank you. Do you think that
Yeah.
taking the mediation sessions from the court premises, this is from Yejide Oshokaye, do you think that taking the mediation sessions from the court premises to more comfortable premises will encourage more senior lawyers and SANs to attend mediation sessions?
More like making mediation like arbitration. Let's put it that way. The whole paparazzi with the whole arbitration paparazzi. Yeah. What are your thoughts on that?
The short answer is yes. You know, and I'm not advocating that you know, SANs should be. I'm speaking for myself now, because I'm sure some people will disagree with me, and maybe very strongly, that they should be treated as a different species, you know. But it's true that it would encourage and get some more enthused about the mediation process. And I think, you know, also, if you, as it's often the case, you know, you are required to bring someone that has authority, that can bind the company. So when you have a lot at stake, for example, I need to bring a director or the CEO. I think, yes, if you are going to be having the mediation conducted, you know, in a fairly comfortable environment, and also perhaps even discreet environment, yes. So, for example, not to beat up on LMDC, but just as an example, you know, you go into the you go to get to the foyer, you go upstairs, you get to where, you know, people see the ante room outside, that people see the reception, you know. And you get there, whoever you meet there, you all know what you guys came for, you know. So it's open, everybody, you know, and then sometimes you are waiting, people are milling around. I don't think, you know, truth be told, a lot of CEOs will be interested in coming and sitting down and what have you. But if they know that we're going to meet at a certain location, we're going to have our coffee and our tea and sandwiches, we can be there all day, it's comfortable, there's Wi-Fi, there's, you know, I can go out, stretch my legs when we take a break, you know, we can, you know. So yes, absolutely. You know, all of a sudden, you know, it's almost like you are at work, you know, in some sense, and you can sit down, thrash things out. You're comfortable. You know, you're not in an environment where you can't wait to get out of the place.
So a conducive atmosphere.
Yeah, absolutely.
I disagree, sir. I disagree, sir.
Mr. Larry, you need to come on the hot seat, sir. We need you.
I'm prepared. I'm prepared.
Thank you.
Let clients appreciate the conditions which we work. Let clients appreciate the conditions in which we work.
What conditions, sir?
Good. Leonard Silk is saying we should have a place we can have tea, coffee, Wi-Fi. I disagree. Let them come to court. Let them see how the system operates so that they can also influence it from their high horses, and let the conditions be improved for the generality of the public. I'm not a communist or socialist, but I believe it will benefit everybody. I was in mediation last week. I didn't leave until 5 p.m. I even cracked a joke. Let's even have cake. The woman looked at me, cake. I, the mediator myself, have not drank water. You want cake? It gives you the sense of belonging to an institution and what needs to be done for everybody. How many clients? Well, Leonard Siki has clients. Otumba of the Source, Chibolaja, he has clients who have planes and things like that. Some of us that we don't have. How would they be? Who's going to pay for it? It's not the lawyers. It'll be the clients that will pay for that comfort. And some of them, they don't have this money.
So thereby, the convenience Mr. Adio is talking about, in your opinion, sir, would make mediation more expensive. And as Fola had said, elevating it or giving it the arbitration appearance.
Yes. Okay. He knows my view about arbitration, and he has advised me on arbitration before. So Let's leave that.
I don't know your views on arbitration, but I think I support your view on arbitration.
So basically, Mrs.
We were doing
question.
one arbitration. The arbitrator said we should pay her 11 million naira. I called Mr. Adio. I said, is the arbitrator okay? I brought the case. They've not paid me 3 million naira. I didn't go.
Okay, thank you so much. Yeah, Mr. Lai, it's so much fun having. So we have a comment from Mrs. Colady, and she says that I disagree. Let everyone appreciate what the public has to go through, including the mediators who are not even well paid.
Exactly.
Because really and truly, sir, and to lend credence to this, we can't say that we want mediation to look like to have the same paparazzi, quote and unquote, as arbitration. My own words, and not have a problem with going to the High Court or Federal High Court, where learners have to probably be in one small court and not exactly have a problem with it. Because I go to the Federal High Court and I see, and I'm like, really? So if we can talk about that for mediation, then how about the regular courts, learners?
So you know the thing about us lawyers, right, is that if we're in the courtroom now, and which we unfortunately we don't have it here, and what we're this discourse was being not only recorded but being transcribed verbatim, and you can see it on the monitor. I would have said, let's go back and read what the question was. So what I said in response to the question as to whether some senior advocates and some executives will be more endeared towards mediation if, and I said yes. So that was the question, and that's the truth. Whether you agree or disagree is of no moment, because the answer is that they will be more endeared. If you want to keep it the way you described, which I understand and appreciate, right? And the value points that have been made, absolutely. But you're not going to see the big girls and the big boys.
But the big girls and the big boys are going to Federal High Court where the chairs are hard. And they're going to linking courts in Lagos.
But you know something? My friend, Mr. Lainga, already made the point. By the time you're in Federal High Court or Lagos High Court or whatever court, there's some level of compulsion. You don't have a choice.
So why not make mediation mandatory? At least to a certain level.
We already discussed that. I doubt that you can make it.
No. The interesting thing, Leonard, and I think I sent a message to Mr.
And let me finish. Even the courts, by the way, the courts are looking to upgrade. So by the time
we know what that means in Nigeria, that's costing.
By the time the Federal High Court, what used to be the annex, which is going to be the main building, completed, it will be a different ballgame entirely. You have in real-time verbatim transcription. You'd have Wi-Fi. You'd have all kinds of amenities on the court premises, an e-library, and so on and so forth. Restrooms that are going to be up to snuff. You're going to have all of those things. So we should be aspiring towards that. What we should be doing at LMDC, and this is not, I'm not saying it's mutually exclusive to what has been said, but even the LMDC, for example, process, there's no reason why over time they too can't scale up and make it more, comfortable and what have you, so that, and then not all the rooms have to be the same. And you can even make it that if certain people want certain types of rooms, you pay for it or you pay extra for it.
Thus making the process a little more expensive and passing the cost to the client.
And cumbersome, if I may.
But the client, if the client doesn't mind, because the client would rather be in a conducive environment, why not?
Well, I would personally like I said,
the predicate of the question is that would it make some people more? And I said yes. The question was not, do I think it's the right thing or not? Okay. And I still haven't said to you till now what my own views, my own personal view is.
I think from the way you answered the question, we have a fair idea of what it is.
I did. In fact, I did kind of indicate somewhat that I don't necessarily subscribe, and I said I'm speaking for myself because some people may object vehemently that, for example, senior advocates on this issue should be treated as a different species. I kind of said that along the lines, but I was talking for myself. I wasn't talking for the body of senior advocates, for example. So that I think would suggest that my sympathies align with what Mr. Layinka and Mrs. Oshuke or Mrs. Kolade have said. But I'm just saying that if you want to get the people in the ivory tower to come, you may need to consider.
Yeah, Abby, sorry to.
There's a question. I would like to hear Chief's comment. But before that, I would like to read Mrs. Colade's question so that he can.
Yeah, because I was going to say that Chief's video is on. Maybe we should hear his perspective on this.
Yeah, but let me just read Mrs. Colade's question.
Comment. Okay. Then.
Yeah, comment. So she says, myself, you are referring to mediation at the High Court. There are a lot of private mediations that are not done in the courts. So, Chief, please, would like to hear your comments on this. Good afternoon again, sir.
Good afternoon, Abby. Good afternoon, everybody. Today for me is just to keep on learning and listening to you experts. So I'm being compelled to speak, but I'm happy Mr. Adio is on the hot seat, and my friend Mr. Olayinka is there to control him. So that is not going to have his way all through. If I may just weigh in on one or two things that have been said. Even in litigation, you have to categorize the party so much as in arbitration and mediation. And like I keep on maintaining, mediation is always a part of litigation and arbitration. In litigation, it's not all war between the lawyers, particularly if there are senior counsel involved. I have experienced so much in talking to my colleagues on the other side, much more than we meet in court. So invariably, we find a way through the myriad of issues that arise from the case. Same thing in arbitration. You know, we have a session today, issues will arise, and I will make the necessary phone call or arrange the necessary meetup to talk further about the case. So I don't know, I'm not going to the particular question, but I think that if the clients come under several categories. If there are parties that wish to go to the multi-door to sit down there and see whether they can iron out, yes, so be it. So I agree that they should be made to come there. But sometimes there are parties who will feel more comfortable with that cake and coffee during the process. So if you're going to get a good result, you encourage that also. Last week, I think you had Mrs. Roberts, and she gave the example of Kolanut, right? The Kolanut example may not necessarily work at the multi-door, but it will work fantastically if you have a private setting. The big boys and the big girls, the CEO, even for court, they are really not there. They are company secretaries or somebody from the legal department who is giving evidence or whatever is the person that sweats it out in the courtroom with you, right? So at the end of the day, there's nothing wrong in coming to Mr. Adio's chambers or Mr. Olayinka's luxurious chambers to have a meeting and see how we can resolve issues. The bottom line is resolving the issue. When you talk about the cost, definitely some cases will cost more than others. If the dispute is really and truly not supposed to be that expensive. An arbitration asking for 11 million naira, we get the kind of reaction that Mr. Olainka gave. That might just shut down the process from day one. I've suggested at the last, and I have this article I think I will share, on arbitration costs. That is gaining some traction among arbitrators, because my brief is that even arbitration is so much more expensive than litigation, right? And that in the dispute resolution agreement, the arbitration agreement, the entire contract, the entire document should have a dispute resolution retention fee. Now, what does that mean? You find out that in contracts, construction contracts or otherwise, they put aside out of the contract cost a particular amount of money and say that if we ever have a dispute, X amount has been warehoused for the resolution of the dispute. What does that do? It limits how much can be spent on dispute resolution. It limits, or rather, it puts the parties at par. So there's not one poor contractor who is trying to get, I mean, the money he has been paid, he has used it on the work, his little profit. There's no way he can fight one of Seni Adio's big clients. But where there's a retention fee, there's a contract, say, for example, 100 million naira contract, and the 11 million or 15 million has been put aside as dispute resolution fee, retention. If there's a dispute, that money is already there from day one. It's been warehoused. And the clause will be allowing for a 6-month period, just like a retention fee. And after 6 months, the monies go back to where it should go, either to the employer or the contractor. Now, if a dispute arises, that is where everybody goes. So the retention fee is there for all to see. This is where the arbitrators get paid. This is where counsel gets paid. So you know what you are throwing in from day one. You are not asking for humongous fees. You know this is the deal. We have 15 million here. We have 3 arbitrators. The arbitrators are going to take between them the 8 million, 9 million. Counsel will take X amount, and that's settled. And you find out that parties will be at the same level. And it can go for all kinds of, all categories of cost. So this medium, I hope you'll be able to encourage such a retention fee to be included in contract. That's number one. Number two, with respect to court-ordered mediation, a court-ordered mediation should be like an order of court, right? That go to mediation. If you resolve, your resolution will be brought back here to be entered as judgment. If you are unable to resolve, your report or the report of the mediator will be brought here, which I will consider going forward. You'll find out that once you've decided to go mediation, if the parties are bona fide, they would agree to it. It is usually where you have the rogue party aided by, without trying to disparage any of our colleagues, aided by counsel, that they start to scream from day one that, oh, mediation should not be binding. There's absolutely nothing wrong with mediation binding. We have too many cases in court anyway, so anything to ease the congestion in the court, right? Particularly civil matters that can be resolved by mediation should be encouraged. So if there's going to be a court-ordered mediation, parties should agree on the outcome of such mediation from the one, and it will be part of the order.
Okay.
You know whether I've made some sense.
Yeah. Thank you so much, Chief. Leonard Silk, I don't know, what's your reaction to what Chief has said before we move on to the next question?
Just if I had anything to add? No, I mean, I think nothing to add whatsoever. You know, I mean, Chief is spot on. And, you know, we've discussed this in the past, as a matter of fact. And I think a very, very creative suggestion, you know, because if in fact you start having agreements, more agreements like that, then, you know, the universe of fees has been predetermined, you know, and maybe you can also, if you want, you know, put in there that, you know, if it turns out that there was really no dispute and the person that brought the claim, you know, ought not to have done it just because money was there, there could also be some maybe language that have been put in the document that would provide for some level of sanctioning. But I mean, Chief is absolutely spot on that too many of our cases are in the law courts, and we need to, you know, try to funnel more of them into the ADR process.
Okay, thank you so much, Leonard. Abby, over to you.
Yes. Okay. So I have two more questions, and then I'm just going to round up and hand over to Fawn.
Okay. I mean, if I may add again, I'm so sorry.
Yes, please, sir. Yes, please go ahead, sir.
We must also try to infuse this mediation spirit in council, you know, maybe through the MBA workshops and all that, so that council begin to know the value. I mean, like my friend, Mr. Olayinka said, bottom line is money, right? And if council can understand that a fee, an earning of 5 million today is worth more than 20 million in 10 years, right? We should come up with a lot of you know, stuff like that. Only yesterday evening, I called a colleague who is holidaying in Texas. I'm pulled up somewhere in London, and we discussed about a case which we are both involved in. And between him and I, we are able to come up with some kind of settlement figure, which makes a lot of sense, you know. So, I mean, we're just waiting to go back and put pen to paper. We're both speaking to our respective clients, you know. I mean, my client, you already have X amount of billions garnished. The other party wants to challenge, and they can challenge for the next 20 years. So why don't you take a cut on this so that you can go home, you are 70 years old, and go and enjoy what you can enjoy before your children finish all your money. And I myself, I'm not getting I'm not getting younger. Let me get my fees down and look on for the next thing. So we should really encourage that. Thank you very much.
More or less, Leonard Silk, Christmas is assured with the fees coming in.
Well, you know, Christmas is not as expensive these days. There are no.
Well, some of us don't have passports, so we don't even know how to go to the airport.
Okay.
No school fees again. No Christmas presents.
I'm still paying school fees.
No,
Okay. Leonard Silks. I'm
Yes.
sure you people have a, you know, I'm sure you guys have a secret code, you know, but so back to the subject matter. Thank you so much, Chief Ayorinde. Mr. Adio, you said you didn't have anything to add to it. Leonard Silk.
Yes.
So there's a question from, okay, so it's a comment. Mediation advocacy training is available to lawyers through SCMA and MBA continuing education. That's from Mr. Okuno. Thank you, sir. So I have two more questions, as I said earlier. And because of time, we'll be rounding up. You know, Fola, I'm going to hand over to you.
Yeah, but I think we should also crave the indulgence of Leonard Silk, because you know, we're supposed to finish by 6:30. To know whether I can accommodate us for another maybe 10-15 minutes.
I think the Leonard Silks are having a jolly time. I can see Leonard Silk. I can see Mr. Adio smiling from ear to ear. Maybe Chief, sir, please, we crave your indulgence.
One thing I would just suggest, since we're the subject, is that I think, you're doing a wonderful job of being ambassadors and evangelists for mediation, but I think some of these things you also need to take into, law firms, and also, all the NBA, whether it's Ikeja branch, Lagos branch, the national is coming up, national conference is coming up, I think in October. Be on one of the programs, to talk about mediation, and really get it out there, because, and another thing is that you can even have it, I don't want to use Spain, but that's really what it is, but it's a positive one, which is that, as lawyers, one day you really can be counsel, in that circumstance, you can be the one mediating. So at the end of the day, it's almost like there's a lot of cross-pollination that can create opportunities and business and revenue
and streams of income.
Yeah, for all of us.
So we'll be contacting you with regards to that, sir. Seeing your close connections with NBA. Please pick my call or respond to my email when you get it. So Fola and I will be following up with you on that. Thank you so much in advance.
You're welcome.
Okay, so my question is, I have a question that goes thus. Comparing your experience in dispute resolution abroad and in Nigeria, are there any international best practices that you think would be of benefit if introduced here?
Wow, that's a very broad question. Some of what I would consider, well, you said best practices, but certainly practices that were designed or are designed to encourage fairly prompt resolution of cases is what we have adopted here. Although, like anything else, it's not always just about the rules or the laws, but the human beings who are going to be implementing those rules and laws and practice directions and what have you. So what I'm trying to say, for example, is I'm going to make another disclosure. Because I left this environment very early on after I qualified, say for about a year, maybe a year and a half, I didn't practice the way, Chief had to practice, in his own time, the way Mr. Layinka also practiced, and I'm sure many of you, which is, I kind of recall the terminology that was used at that time when you could easily ambush people, ambush tactics, So in the US, what we call front loading here, they call it motion practice. So by the time I came, it was as though it was designed for me. Yeah, names of cases are different, but the procedure of how you conduct is exactly what obtains there, front loading and what have you. So that's one thing that's been adopted here that I think is a positive, although of course, some lawyers have also found ways to still be recalcitrant and dilatory and delay and what have you. But in addition to that, right, part of best practice, I feel, is again, where a case merits summary judgment being entered. So long as that case merits it, our judges should be bold to enter summary judgment or partial summary judgment. Then, another aspect that really irks me is, you file a motion, it almost, not in all cases, but it almost doesn't matter how exigent the circumstances. Some judges, not some, many judges will just tell you outright, I don't grant ex parte orders. Others are maybe in receivership proceeding. What are maybe receivership?
Leonard Silk, you're talking about litigation.
Yeah, you're talking about, you're talking about mediation. Mediation, yes. One thing that I don't see here, so I was talking about litigation, yes, so that's my default. One thing I don't see here a lot of is, there's a process called the early
neutral evaluation.
Neutral evaluation. I don't think it's something that people do here that is prevalent in this environment. I think it's something that we can adopt. People don't talk too much here about conciliation. I mean, I know a lot of the people on this platform, people like yourself, Fola, Mrs. Oshokeye, Mrs. Kolade, and many others, they are very familiar. You're ADR experts, but the general legal community, maybe they'll use common sense to interpret what conciliation means and what a conciliator does, but tell them to distinguish what it is between conciliation and mediation and their stock. So that's another aspect that, and abroad, a lot of businesses actually pay for having an early neutral evaluation of their cases, because a lot of the cases actually go or get close to trial are what big companies call bet the company cases. And most of those cases, eventually somebody blinks. Nobody wants to roll the dice, as they say. So that creates a lot of work, if you will, for ADR practitioners who do that, early neutral evaluation.
Okay.
Thank you so much, Leonard.
Thank you so much, Leonard. So I usually don't do this, Leonard. So I'll just ask two very short questions and call it a day. Now, the first question, I'll take both of them together, actually. Now, the first question, Leonard, is this: some schools of thought believe that, I have the opinion that litigation should be taken out of commercial matters, and the whole ambit of anything commercial should be thrown into the waters of ADR, vis-a-vis negotiation, mediation, and arbitration, since the foundation of most commercial matters are usually contractual, and they always have to do with some kind of negotiation, bending backwards, and all of that. And that if commercial cases are taken into ADR, it would also help in reducing the backlog of cases and all that. And then that litigation should now probably be for criminal matters that need judicial pronunciations, amongst all of that things. But anything commercial should be taken into the waters of ADR. Do you agree, sir?
I disagree completely.
Okay, sir.
Sorry, if I may just weigh in briefly on that. Particularly with your question regarding best practices abroad. First of all, Nigerian counsel should also be encouraged to be very firm with their clients. It's very, very important. That may be something you grow into, or something you grow your clients into. Very difficult for a client to tell Mr. Olayinka or Mr. Adio SN that, oh, go to court and go and do this.
Oh, Chief Bolaji Ayomide.
Well, I mean, I've had the experience, even in international arbitration, with all modesty and humility, I've participated in some of the biggest arbitrations concerning Nigeria. And on an occasion, I flew into the UK for an arbitration to start the next day. And on the morning of the arbitration, a counsel calls me from the Federal Ministry of Petroleum to say, Chief, please, the best thing you can do for us today is ask for an adjournment. And I'm inside my taxi heading for the seat of the proceedings. And I just kept quiet. And she said, oh, are you still there? I said, yes, I'm here. But I'm not going to do any such thing, right? Because I have my reputation, my name, and everything on the line. Then I go before a Lord Hoffman, who retired from the Supreme Court here, and start asking him for an adjournment. I mean, it won't happen, right? If the best I could do, if your witness is not going to be available, I can plead with the tribunal to start with the other parties, right? And then our witness comes in the next day and all that. That's the best I can do, right? If you're not going to be ready, I'm going to tell the court or the tribunal that you're not ready, right? That's my bit. And, secondly, and that is why I keep on saying that mediation is so wide. It dives into litigation and arbitration.
They're connected.
Yes, they're all connected. a particular instance, we finished the arbitration proceedings, and I wrote an opinion to my client and say, this award
Needs mediation.
This arbitration. And I said, this award is going to be against us for this and this reason. The best we may have is a divergence of opinion as to quantum between the three arbitrators, but the three of them are going to rule against us. Now, pre-award, I want your instruction to engage the counsel on the other side. Pre-award, right? Let us now engage them that if they get their award today, they will leave a 90-day window before they commence any form of enforcement proceedings. And within the 90 days, whatever award is given, right, then we can negotiate on how to go about it. So, so you can also have a pre-judgment, a pre-arbitration award mediation, and say, look, let's keep talking even after the adjournment for delivery of the award. And it worked. You know, we started talking. So by the time the award came, you know, we had a platform for a settlement, right? So all these things, they come, yes, you know, some with experience, but also your platform, like Seni Adio said, you know, we really must have a roadmap. We must have a roadmap into getting into the lawyer forums. I'm happy my senior brother, Mr. Okuno, has suggested that, look, this exists and that exists, right? I think it's something we should take up and get in with the people that organize these things, and all the outcome of your meetings on these platforms and all that, we begin to put together very well and use it to influence lawyers. Thank you, Mr. Adio. I've learned a lot from you as usual. Thank you very much.
Thank you. Yeah, thank you so much, Chief.
Thank you, sir.
Yeah, so do you want to give a bit of context to your no very quickly before we take the last question for the day?
No, well, the context has to do with a number of things. One is that I think Mr. Olayinka already alluded to it, that, you know, citizens have a constitutional right to the courts. So unless you want to amend the Constitution somewhat, you know, otherwise there's just no way you can say, you know, you're going to say commercial cases should go to mediation. That's number one. Number two, you know, there is, I mean, businesses should have a choice and make the choice based on, you know, there are times when you also need to be mediation. For example, you need to develop a body of laws or decisions. Of course, know that sometimes you need to go to court for interim orders, and also a myriad of reasons I can't think of readily right now, you know, that you want. And then, of course, there are times when you also need a judgment wherein you also even want exemplary damages to be awarded against the other side, you know, and so on and so forth. You know, I'm not sure you can get all those kinds of reliefs through a mediated process.
I agree with you.
So for all those reasons, including the fact that, yes, some of us are litigators and it's going to hurt our wallets.
I agree. Thank you so much, Leonard Silk. My very last question, we have a cross-section of lawyers, mediators, and end users watching, and this is also broadcasted live on YouTube for people to actually go back and watch. What are your final words to everyone as far as mediation is concerned?
Well, you know, I'll be very succinct. I think definitely it has come to stay. It should be embraced. It's, you know, the process is confidential, it's effective. The parties are the ones that really, you know, play the lead in terms of coming to a landing, a resolution. And like I said, even if you don't resolve, you preserve more often than not relationship. you get an honest insight as to the strengths and weaknesses of your case. Indeed, mediation is also being encouraged by our law courts. I gave examples, Order 16 in the Court of Appeal rules, and I think it's Order 18 in the federal rules. I believe the Supreme Court also has a mediation mechanism in the court's practice direction, and so on and so forth. So it's definitely here to stay. What we should do is embrace it, master it, and take advantage of that, so that a lot of the cases that are the law courts now many of them can be resolved through mediation, frankly, and they should be so resolved.
Okay, thank you so very much. Unfortunately, we may not be able to take so many questions. As always, I want to.
Can I just fight? That was my last words regarding mediation, but I also enjoyed the program. I enjoyed being here, and obviously I thank those who are on the platform. It would not have been ideal to be talking to myself or talking to just yourself and Abby. So to my Egbon, Chief Bola Janride, my good friend Larry Yinka, all of you. Also, I had already saluted Mr. Yomi Okunu, who's a very, very, very senior lawyer as well. And, I already had a lot of fun doing this. And I too have learned a lot, even though I'm the ones on the hot seat. So thank you, Mrs. Oshunkaye, Mrs. Kolade. I mentioned those people because some of them, many of them I know, but all of you, each and every one, even those who haven't identified, it was good being with you, and thank you for listening.
Yeah, thank you so very much. And next week we'll be having Honorable Justice Wally Harriman on the hot seat, and we're going to be looking at the synergy of the bar and mediation. So please let's make it a date next week, Saturday, to tune in prime time. And thank you so much everyone for tuning in. It's been an interesting and insightful session, and until we come your way again, I wish everyone a beautiful week ahead. Thank you everyone for tuning in.
Thank you.
Thank you so
Bye-bye.
much. Yeah,
Thank you,
bye.
Chief. Thank you,
Bye.
Leonard Silk. Thank you, Mr. Olainka.
Yeah, thank you.
Mr. Valentino, we see you.
Mr. Olainka needs to be on the hot seat too. I already have an
Don't worry,
isolated
we're
topic for
working
him.
on it.
No, I
Thank
have the
you,
topic for
Eunice.
him. The topic is mediation, mandatory mediation, to be or not to be.
Or not to be.
Yes, that's it.
I'm sure Mr. Adio would love to be there.
Yeah,
Chief, we're looking
mediation
forward to you being on the hot
be
seat,
or
sir.
not to be. That's the
You want my
isolated
answer
topic.
now?
No. It's
going to be a session for you, sir.
It's going to be a session because we're going to really, really go back to the very essence of this. Thank you so much, sir.
Thank
Okay,
you so much, everyone.
Just want
Have
me
a
to
great
support your
weekend.
position. You want me to support your position, Fola?
No. I want you to be.
Don't worry. Don't worry. I still have
Okay,
a brain that is working.
Yeah, thank you so much.
All right.
Okay, goodbye.
Bye.
Thank you.
I'll get your details from Mr. Seni Adio. Thank you so much.
Yeah.
Okay, then
All right.
bye.